Hello, everybody. Good morning. Happy Sunday Fun Day, or good morning, or good afternoon, or good evening, wherever you are in this beautiful world of ours. Thank you so much for joining us for Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. This is going to be a good one. I am juiced. Kaylin's juiced. Tiffany's juiced. Everybody's worked up this morning because we're very excited about the questions that you guys sent in. My name is Joshua Ritter. I am a former LA County District Attorney. I was a prosecutor for 10 years here in LA County, and then I went into private practice, and this is Courtroom Confidential for everybody who is new here. Thank you so much for joining us. Our mission on this channel is to present to you both sides of the courtroom, and we hope that we do that. So hello to everybody in the chat, Flora Paris and Pammy and Alicia K. Mayo, and there's Sonia, Shy Gal, and Madeline PT, DPT. Got to figure out what those stand for. Farm Girl, K9 Catherine. Thank you, everyone, for being here. This is the plan for this morning. This is Sunday Fun Day. If you are new, Fauna in the Forest became a brand new YouTube member. Thank you so much. I appreciate that. Thank you for this great channel, Josh. All the mods, members, chatters, you all combined to make this such an enjoyable experience. Oh, how touching. I appreciate that. Thank you. You put me even in an even better mood. This is the plan for Sunday Fun Day. We let you guys go to thecourtroomconfidential.com and leave us a voice message. Throughout the week, you leave those messages. We do the research. We find the answers. And on Sunday, we answer them live. And that is the whole point of Sunday Fun Day. So hello to everybody in the chat. Hello to everybody who's watching this on replay. Hello to everybody on Facebook who's watching this. If you haven't already, please hit that like button. Please subscribe if you haven't already. Please share this with someone who you think might enjoy Sunday Fun Day. We're trying to get the word out. And then stay to the very end, because we do have some announcements for you, some fun stuff that we hope that you guys are going to enjoy. But without any further delay, let's start to jump into these messages, because I'm very tickled by the stuff that you guys came up with this week, and we have some little surprises for you along the way. All right, let me make sure I'm all queued up, because this is the first time where I actually have to do something. And already, Kaylin, already you've let me drop the ball. Here we go.
Hello, this is Gloria from Florida. I just had a question about the Karen Reed case. I was curious about the added charge that the defense was able to add in, the OUI, which she was eventually convicted on. It seems counterintuitive that the defense would add charges to the case where there were already a lot of charges. What were there, 14? And I was watching the case fairly closely, but I don't remember when that happened. Maybe it was early on with the motions, I don't know. But I just was wondering when that got added, and has that ever happened? It just seemed kind of odd to me. But okay, well, thanks very much. Bye-bye.
Jen from Ontario, Canada, thank you so much for kicking us off. The other thing I didn't add is that if you call in and leave us a message, we put you on our map. So let's go ahead and add Jen from Ontario, Canada, to be the first one to ask a question this morning, and it's a good one. She's asking about the Karen Reed case. First of all, I am not a map maker, but that does not look like Ontario, Canada to me. But anyhow. What did I say? Gloria. Oh, shoot. Did I miss somebody? Oh, did I say Ontario, Canada? I meant Florida. I don't know how I got messed up. This is Gloria from Florida, correct? Right. Let me start it over again. Did I mess this up so bad already? Hold on.
Hello, this is Gloria from Florida.
This is Gloria from Florida, Joshua, not Jen from Ontario. This is Gloria from Florida, so everybody was right but me. Go ahead, Kaylin. Sorry. Gloria from Florida, for kicking us off this morning. Still asked a Karen Reed question, so at least I got that part of it right. I like the question a lot too. So thank you, Gloria from Florida, getting it right. You ask about the OUI charge, the under the influence charge in the Karen Reed case. And you have some great questions that I think a lot of people breeze by. First of all, why did they do this? It seemed like counterintuitive. That's a great way of putting it. Two, when did they do this? And are they allowed to do this? And how common is this? Well, let's start with the last one. How common is it? It's not common much at all from the defense. From the prosecution, sometimes, yes, charges will change. Sometimes they'll add charges. The way that a trial works is that you go in with your charging document, whether that's a criminal complaint, whether that's an indictment. And then as things are proven throughout the trial, sometimes you will amend things at the very end to conform to proof, to conform to how did things actually play out in court. So let's say you've got a case where you've charged murder and some, other circumstances. Perhaps it was kidnapping, let's say. And in the course of the trial, the kidnapping charge is not really proven. Well, the prosecution can say, you know what? We're not going to ask the jurors to come back on something that we don't feel confident about. So we're going to remove that charge from the jurors. In the Sean Diddy Combs case, they just did this recently. The federal prosecutors removed some, not actual charges, but predicate acts, but they removed some things from consideration. It can also work the other way. If in the course of the trial, a murder trial, it turns out that there was elements proven of kidnapping, there is some argument to be made that they can add the kidnapping. Now, I don't want to get into the whole whether that violates notice requirements and everything else, but sometimes you can add charges. In the Karen Reed case, though, this came from the defense. They said, we want to add this under the influence charge. And you say, well, why in the world? She's already facing all these charges. Why would they want to add a charge? I think this was probably one of the smartest strategic moves that the Karen Reed defense team made. And that is because I think they realized psychologically, the jurors sitting here realized that a man has lost his life, that they put on an entire trial that went for 30-something days, that it might be more difficult for all of those jurors to agree to completely walk Karen Reed out the door, a free woman, on everything. And if they give them something for those jurors who might be a little hung up on the charges, something to hang their hat on, something to feel like they've at least considered, evaluated the evidence, and come back with some sort of conviction, maybe they'll go for that. It was not even so much of a split the baby idea as much as was what you might call like a lost leader concept. Let's give them the OUI because they didn't care about the OUI. She was sentenced that same day. She got probation, 1 year probation, no jail time. She'll have that thing removed from her record by this time next year. So they thought, you know what? It is proven there are elements. She actually did admit to being under the influence. Let's go ahead and throw those jurors who may be on the fence that bone and hope that they go for it. It was done right before they went into closing arguments when they were discussing all of the charges and the instructions to give to the jury. And it did conform to proof. And they made the argument that, hey, we think this should be a part of it. And that was, end of the day, the only thing that the jurors convicted them of. So great question. Something that kind of got overlooked initially, but I think it was a very smart strategic move on the part of the defense. And I think that's everybody who was in the know knew where they were going with it. Arizona Gal 89, thank you so much, says, I rescheduled my counseling client to be here live. Love this community. Tell your counseling client I am so sorry, but they should join us to at least see what they're missing out on. But that's very sweet of you. Appreciate that. Alicia K. Mayo has been a member for 8 months. Congratulations on the tremendous, well-deserved channel growth. Love all things CC. You guys are fantastic this morning. I'm feeling a lot of good vibes. And then Jami Shari just became a YouTube member. Thank you so much. This is where we're all pumping on all cylinders this morning. And Crazy Mom RN, coffee for Josh, member for 5 months. I do have my coffee in my Courtroom Confidential mug, so thank you for that. Pour myself a hot cup after this. Anyhow, Gloria, not Jen. I appreciate you. I thank you. I'm sorry that I got things off to a bad start, but we knew that was going to happen. Didn't we all know that somehow I was going to mess it up early on, but hopefully that will be the last mistake. We'll see how this goes. All right. Here's our next question.
Hey, Josh and everybody at Courtroom Confidential. Thank you for all your hard work. I can never catch it live, but I'm always on the replay. But my name is Wendy, and I'm from Nicholasville, Kentucky. And I was just wondering if you think Bryan Kohberger will be offered a plea deal, or is that off the table completely, or how do plea deals even work? Thank you so much for everything you do. Have a good day. Bye-bye.
All right. Neither Gloria from Florida nor Jen from Ontario. This is Wendy from Nicholasville, Kentucky. And there you are. There is the correct map. Josh has now got his head together. Thank you so much. Great question as well about the Bryan Kohberger case. Will he be offered a plea deal? My suspicion is no. And this is how plea deals work. The government can offer a deal on pretty much whatever they want. If they want to have him plead to murder, if they want to have him plead to second-degree murder, if they want to have him plead to murder and take the death penalty off the table, they have much more wide latitude in the offers that they make to the defendant. The judge, by the way, this is something that can happen as well. It's called an open plea. You can go to the judge directly and say, I can't deal with the government, the prosecution. They're not helping me out here. Your Honor, you give me an offer. The one caveat with that is you can't change the charges. You have to what's called plead to the sheet. So you can take an offer from the judge, but the judge has to make you plead to everything. He's charged with first-degree murder and special circumstances. It gets a little iffy in there whether or not the judge could take the death penalty off the table. That it would be taking something away from the executive branch. And that's really what you're seeing here. You're seeing the meeting point between the judicial and executive branches, the executive and the prosecution, judicial, and obviously the judge. And they have different powers on what they can do. So to get down to, though, the nuts and bolts of what's actually occurring here, I think that the government, the prosecution, has probably not made him an offer. They are probably saying, no, we're pursuing the death penalty. If you want to go ahead and plead guilty to murder and go through a penalty phase, perhaps they've allowed for that, but we're seeking the death penalty. They cannot say plead to the death penalty, but they could say plead and we'll just do a penalty phase. We saw that actually out of the Parkland trial with the Parkland shooter. It was only a penalty phase trial. What usually happens in these cases is if the prosecution is going to offer anything, it will be plead to first-degree murder, and we will spare you the death penalty or even a chance at it and sentence you to life without parole. You do see that happen quite often, but I don't think they're offering that here. I think they feel that this is the most convincing case for the death penalty that they probably ever run across in Idaho, and they're not going to offer anything less than that. And the judge probably feels like he doesn't want to get involved. He's going to allow this to be in the hands of the prosecution. Everybody, I think, knows this thing's going to trial. He's fighting for his life, and that's where we find ourselves, where we're at. But great question. Sarcasm says, I didn't know you could ask the judge. I learn something new every day. Oh, good. Glad you're here. Already worth the price of admission, which is absolutely free. Thank you guys for being here. Pammy's been a member for 10 months. Oh, coffee for the mods now. Yeah, they need it. They need it after that false start of mine this morning. They were all freaking out, and I had no idea why. All right, let's keep it going. Now I'm double checking myself just to make sure I don't mess up.
Hi, my name is Jen. I'm calling from Ontario, Canada. Thank you to Josh and Tiffany and the mods. I appreciate everything about your channel. This is about the Karen Read retrial. Karen Reed, that is, made it very clear. She said, "Oh my God, I hit him with my car. OMG, repeat, repeat." I don't know how many times she said it. This was the alleged or the supposed time of the accident, death, whatever you want to call it. So how did they get over that? I realized that you can say things and be guilty of things, and then you can plead not guilty to things. But in your opinion, I don't understand how they were able to get over this huge hurdle. And they were victorious. And I do believe that it was gutsy of Jackson, and I think that they did have a dream team. I mean, I'm sort of stuck on this because is that what's called an excited utterance, or is that something that they overlooked because like she was intoxicated or out of stress, or if she had hit him with the car at a certain speed, then the injury wasn't fatal? And sorry, my question isn't as precise as I wanted it to be. Anyway, I was just stuck on that. Thank you.
Now, see, I knew a Jen from Ontario was coming up. There's Jen from Ontario, and there's Ontario, which clearly looks different from Florida. So thank you so much, Jen, for asking this question about the Karen Reed trial. And you're asking, how did they get past the hurdle of the statements that she made? I ask the same question. I think the most powerful evidence in this case in support of the prosecution was the words that came out of Karen Reed's own mouth. They had, several statements that she made to the media, statements that to me seemed highly suspect and possibly incriminating and appeared to be admissions. And I thought the prosecution played those to great effect. And I said, if she's going to go down for any kind of conviction, it's going to be because of these statements that she made and not anything else. But she didn't go down. Obviously, the jurors saw past all of that, weren't bothered by it, weren't troubled by it. And your question is, how did they get past the idea that she said, I hit him, I hit him, I hit him? Now, I've seen a lot of people in the comments saying it was, did I or could I? Here's the thing, though, and Jen makes a very good point. The evidence was that she said, I hit him. The witnesses called said, I hit him. Her contention was, it was did, and Jackson had questions about could it have included did, or could it have been could I hit him? And I know that there were at points some equivocation by some of the witnesses, but the evidence from first responders was she said I hit him. You may not agree with it, you may not like it, you may feel that she really never ever said that. I'm saying the landscape of the evidence, the transcripts are that witnesses said, this woman said, I hit him. Given that, how did the jurors get past that? And why was that admitted? Well, first of all, though it may be an excited utterance, it was admitted because it's a statement made by the defendant, which all of those statements get in regardless. But I think the jurors, just end of the day, I think maybe that testimony from Dr. Marie Russell about kind of people who are in the throes of trauma might say things, might admit to things, might confess to things that they didn't do. I think they might have chalked it up to that. I honestly, though, I think end of the day, the jurors, after hearing from the experts, just simply did not feel there was enough evidence and simply felt that there just was not, it could not be proven by the government that there was a vehicle on pedestrian accident here. But make no mistake, that those words are in evidence. And despite that, the jurors saw things differently. So great question, Jen. Appreciate you asking it. One day I feel like we won't be still concerned with all of the inner workings of the Karen Reed case, but I do appreciate the fascination with how that all played out. It was pretty remarkable. All right, let's keep it going here. Do you guys like the new background, by the way? If you didn't check out our last Wednesday night live, check out our last Wednesday night live where you got some movie magic Our special effects department was in hyperdrive for last Wednesday. If you saw the reveal of our brand new background, and I hope that you guys like it. We worked pretty hard on it. I know it may not look all that flashy, but it took a lot of work. All right, let's keep it going.
Hi, Josh. First time caller. Diane Materi here. I have a question about jurors. Jurors that we see on the trials that we watch, they have an admonishment that they're not supposed to talk to anybody or Google anything or watch TV news programs or whatever. How do grand jury jurors handle what evidence they're being presented with? And they serve for such a long period of time. Do they know anything about the crimes that they're being presented, or how does that work? Thanks for letting me know.
Diane, love the question. I have one small issue. You didn't tell us where you're from, Diane, so we can't put you on the map. You're a first-time caller. It's so great to hear from you. I'm so glad that you worked up the courage to leave us a message. We just knew where you were from, and if you're listening right now, tell us. But great question, and this is something I've never thought about. So Diana is asking about grand jurors. Are they under the same kind of sequestration orders and limitations as trial juries? First of all, if you didn't know the difference, there are two types of juries. There's what we call the trial jury, or they even refer to it, if you're trying to be fancy and in law school, as the petite jury. That's the 12 jurors, or depending on some states, less, that decide facts and decide guilt or not guilt in a trial. Then you have what's called the grand jury. It's called grand jury because it's got more members, and they decide different things. They have different questions presented to them. And your question is, well, we know that trial juries, they're told not to avoid the news. They're told, they're asked a lot of questions about whether or not they've heard about a case before they're allowed to serve on it. How do they do the same protections in a grand jury? And the reason I think behind your question is because grand juries, by the way, sit for longer. It's not just one trial. They sit for a period of time. In Los Angeles, where I practice, the grand jury on the civil side serves 1 year. If you become a grand juror on the civil side of things, you're a juror for 1 year. You don't show up every single day. They convene at different days, but you have your jury service that lasts for 1 year. If you're a grand juror on the criminal side of things, you serve for 30 days. Again, it's not every single day, but you are convened. That one group of grand jurors is convened for 30 days. So in Los Angeles, again, it changes from jurisdiction to jurisdiction. I'll just tell you how it works here in LA. You have 23 members who sit on the grand jury, and they are tasked with doing different things during that 30-day period. One, they sit in total silence. Secrecy is one thing to keep in mind. The proceedings of the grand jury are not open to the public. The findings of the grand jury are not open to the public. The witnesses called are not open to the public. It's all done in secrecy, and we'll explain why. But one of the things they do is hand down indictments. If you hear about a grand jury indictment, this is what we're talking about. It's where the prosecution has come to the grand jury instead of filing traditionally a criminal complaint. In most jurisdictions, the vast majority of the time, when you're filing criminal charges, you file a criminal complaint. Somebody gets arrested, the DA's office decides what to charge them with, and they file a criminal complaint. That person then shows up to court for their arraignment, and the next thing that happens is what's called their preliminary hearing. A preliminary hearing is a probable cause hearing. It's the first time that the judge hears anything about the case, and the judge has to decide, is there enough evidence, just enough, to hold this person to answer for trial? There's no jury there. There's just the judge. It's a lower standard of proof. That's called a probable cause hearing. The grand jury acts as the probable cause hearing. So it kind of skips a step. You don't have a grand jury and then a preliminary hearing. If you have a grand jury indictment, the next thing that happens is trial. So the grand jury hears all the evidence from the prosecution and decides, is there enough evidence to ask this person to stand for trial for these crimes. The interesting thing about that is that only the prosecution is present. The defense is not entitled to be present, to ask questions, to present witnesses. They do at a prelim, but not at a grand jury. So the prosecution has to wear two hats in a certain degree. They have to present some exculpatory evidence to the grand jury so that the grand jury is getting a fulsome understanding of what took place. Now, you can already do the math and realize that they're probably not doing the greatest job of presenting all that evidence, but a lot of latitude is given to the prosecutors in how they do this. And it's very rarely will you see an indictment thrown out because some evidence was not presented to them. As a defense attorney, when I've received indictments, that's usually my first complaint is they didn't call this witness. They didn't ask these questions. They didn't present this evidence. But it's only used in rare circumstances in most jurisdictions. It's used when you have a very large case. You've got 20 different defendants and 100 different counts, and you don't want to be stuck doing a prelim on that could take 3 months to do the prelim. So you go to the grand jury. It's much more streamlined. You get it all done. You get yourself an indictment. Or in a very high profile case where you do not want the person who may be even the subject and target of the indictment to know they're under investigation. Or a case where you know it's going to be an absolute circus if you put the prelim on. So in very high profile cases, sometimes involving celebrities or things that they know are going to get a lot of attention, sometimes they'll go to the grand jury. The other thing that the grand jury does is investigate. Sometimes a question will be presented to the grand jury. Sometimes the grand jury serves the purpose of getting somebody's sworn testimony on the record, even though you don't feel like an indictment is coming along. I'll give you a little inside baseball on some of this. You know how recently the murder of Tupac Shakur was, the man was arrested. What is his name? Dwayne Davis, I think, out in Las Vegas. That case had been in front of a grand jury several times in the past. They had convened a grand jury, taken sworn testimony, kept a hold of that sworn testimony, but didn't indict until they got to the point where they could indict. There are big profile cases that I cannot tell you about that have had grand juries convened on them that the government, the prosecution just does not feel like they have enough evidence just yet. But the grand jury can serve that purpose of kind of acting as an investigatory body. Anyhow, because of all of that, usually the cases in front of the grand jury are not a case with media coverage because they are secret. They have been under secret investigation. They are not, the proceedings are not revealed to the media. So the threat of them being affected by media is not the same threat, not the same concern as you would have with a trial jury where the person's been charged, it's out in the open, they've maybe had their prelim, the media has been covering it for forever, and now they go to trial and they got to ask people, what have you been reading about all this? I hope that all makes sense. I think I carried on far too long. You probably learned way more about grand juries than you ever intended to, and don't get mad at me. Tell Diane from an undisclosed location you appreciate the question. All right. Farm Girl, member for 10 months. Congrats on 36,000. Love CC in this community. Well, we love you right back, Farm Girl. Appreciate it. All right. Let's keep it moving here. Oops.
Good morning, Josh, and all at Courtroom Confidential. This is Lizzie, or you can call me Marie, from Manchester in England in the UK. I would like to say a big thank you for everything you do, informing us, especially people in England, and keeping us up to date with law and just everything. I think you're amazing. And I have one request. Could we have some more Kevin Fixler? I need a Fixler fix. Thank you.
Marie from Manchester, England. Thank you so much. Are we a Man United or Man City fan? And I don't know if I'm going to set the internet on fire by even asking that, but I'm curious to hear from Marie. Thank you so much for calling in from Manchester, England, and hello to our friends across the pond. Marie, I heard you. We all heard you, and we know that you can't go too long without your Fixler Fix. Thank you so much for the kind words. So that's why this Monday, tomorrow, we're bringing him back on the show. Time's up for Bryan Kohberger. We're heading to trial. No further delays. Kevin has all the latest on it. There's also a hearing tomorrow, I believe, in Pennsylvania to decide whether or not some of these witnesses will be called. These out-of-state witnesses will actually have to make the trip out to Idaho. So a lot of updates for us to go over. Kevin's excited about it. He's a fantastic dude, and I appreciate him coming on. So, Marie, you ask, we deliver. We're bringing you Kevin Fixler tomorrow night. June Sidalaka says, I really like the new background. I would suggest a few pictures behind Josh. We're working on that. If I could see Tiffany right now, I think she would be nodding her head emphatically because she wants to put up pictures too. We're working on it. It's a work in progress, but we appreciate the feedback. And thank you so much, Marie, for asking the question. And Sherry M just became a brand new YouTube member. Appreciate you, Sherry. Thank you for welcome aboard. All right. Where are we at? Get yourself together, Joshua.
Hi, Josh and the Courtroom Confidential crew. This is Jen M. calling from Fall River, Massachusetts. So glad we're finally done with Karen Reed. I'm now obsessed with the Gilgo Beach and Rex Heuermann. My question is, he's being tried in state court, but now it seems there might be evidence that he had also killed in maybe 2 other states. Could he be charged in the state case and then also federally if it is found he murdered in other states, or how would that work? And how would that work jail-wise? Would he stay in state prison or would he go to federal prison? Thanks.
Jen from Fall River, Massachusetts. Thank you so much. Where's Fall River? There it is. Well, there's Massachusetts. I recognize that. Appreciate the question, and it's a good one. There we go. Let's zoom in a little bit for Jen so she feels appreciated. You've moved on from Karen Reed. You're right in Karen Reed's backyard, or she's in your backyard, and now you're obsessed with Rex Heuermann. So are we. So, could he be charged federally? Great question. Here's the quickest answer, and I won't get into the weeds so much on this as I did with the grand jury, but the federal government has jurisdiction over the entire United States, and there's a penal code for the federal government. That penal code includes things like murder. You commit murder anywhere in the U.S., and the feds can charge you. However, they allow the individual states, to handle their own business, as it were. Every state has its own penal code. Every state has murder on the books. So every state is usually handling their own murders. In rare circumstances, the feds might get involved. We've seen them get involved in the Luigi Mangione case. They decided that for reasons, I think it had to do with kind of an assassination, terrorism, they wanted to get involved. The feds are involved in the case of the murder of the congresswoman in Minnesota because they felt like that's an assassination involving people who are elected officials. They wanted to get involved here. It's more of a function of what does the federal government feel like is a national issue than whether or not things have happened that have invoked federal jurisdiction as far as did it take place in several states. So to your question, he could be charged federally. He's not going to. Does the fact that he may have committed murders in other states, and I know there's suspicion of that, nothing's been, no prosecutor has come forward and said that's happening. But for the purpose of your question, let's say he had committed a murder in Nevada or Florida. Would that turn it federal? No. Nevada and Florida would handle their own murders against him. He would have his trial out in New York, and then they'd ship him out to Nevada, put him on trial there, ship him back to Florida, put him on trial there. Ever heard of somebody named Lori Daybell? She got tried for murders in Idaho, shipped down to Arizona and tried for murders and attempted murder there. That's usually how it would play out. The feds don't get involved just because it involves multiple states. Now, if it involved crimes taking place across state lines, in other words, is he kidnapping somebody in New Jersey and transporting them to New York to commit a crime? Maybe then you might see where the feds would get involved. But many times these crimes take place and just one jurisdiction decides to do it, usually where the more serious crime is, and they just prove up those other crimes, though the person cannot be convicted. In other words, you can't get convicted for a New Jersey kidnapping in New York, if that makes sense. And then finally, to your question about where would they serve their time? It's kind of like first come, first serve. Harvey Weinstein, another example, was convicted for crimes in New York and convicted for crimes in California. He's going to do his New York time before he does his California time, just because he was convicted first there and then second in California. But Jen from Fall River, Massachusetts, excellent question. I hope that clears things up, or didn't, at least at the bare minimum, confuse everybody further, which I feel like I have a talent in doing. All right. Not me. Technical issue, not involving me.
Hey, Joshua, Maj, crew, chat, guest. It's Alicia K. Mayo from Humboldt, Tennessee. So a coworker told me the other day that she is the niece of both Donald and David Demag. I think that's how you say the last name. It's Demag. One was the last person executed in the state of Vermont, apparently, and the other became a U.S. Marshal. I do not hold her any higher or lower regard regarding either one of her uncles, but couldn't find a whole lot about either one of her uncles. So if you could, Joshua, tell us about it. Thanks. Happy Sunday, y'all. Bye.
Alicia K. Mayo, love to hear you. Humboldt, Tennessee. I'm coming out to Humboldt, I think, now. I've heard so much about Humboldt. Actually, I've heard nothing more than Alicia K. Mayo lives there, but I feel like you do a good job of selling the tourism of Humboldt. Maybe you'll make a trip. Donald Demag, you say, look, find out what you can about this man. So we did. You are right. Donald Demag, there he is, was the last person to be executed in the state of Vermont. So here's the Cliff's Notes, and we can get into that whole debate again about if it's Cliff's Notes or Cliff Notes. I think it's Cliff's Notes version of the Donald Demag case. He was convicted for murder, and he received life without parole. Then in 1952, he escaped from prison in Vermont along with another inmate named Francis Blair. The way they did this in 1952 was they just took the laundry truck from the prison and crashed it into the gate and ran. Extremely sophisticated stuff. Over the course of their escape, or soon thereafter, Demag decides to rob a poor woman by the name of Elizabeth Weatherup. And in the course of that robbery, he ends up beating her to death with a lead pipe. He is captured 2 days later. Well, now the state of Vermont has had enough of him, and they decide that this time, for this murder, he's getting the death penalty. And he was executed by the electric chair in 1954. And that's unlucky for him because by 1987, the state of Vermont had abolished the death penalty. So that's why he's the last person from 54 to 87. They didn't have any other death penalty executions, and he was the last one. That is the distinction that he carries. Annalie Finch says, great questions. I agree wholeheartedly, Annalie, and thank you so much for being here. All right. Kristen Perry says, thank you. Thanks for more information on this. Yeah, interesting case. I'd not heard of that. And I do like these little kind of historic deep dives that we sometimes go on. All right, let's keep it going here.
Hey everybody, it's Holly in Houston, Texas. Just finished today's Sunday Fun Day, and I want to re-ask my question now that I can think a little bit clearer regarding the use of AI in trials. I'm sorry, I have allergies going on. We've had some bad storms. Anybody in the South probably knows what I'm talking about. Yeah, it makes me fuzzy brained. So let me have a do-over. And that is because AI has become so hard to tell, as Josh said, between what's real and what's not. How are judges, and I'm assuming they are, they have to be on top of this, but if they're not, that's okay too. Kind of not okay, but I understand because it seems like it happened overnight, right? For AI to go from you could tell because there was a little something to, oh my gosh, I have no idea. So are there any laws and or rulings happening or have happened to safeguard against evidence slash exhibits being faked in a trial or altered using AI specifically? So again, sorry for the do-over, but I hope that this was better. I hope they're on top of it, really. Okay, thanks, guys.
Holly, so good to hear from you. Holly from Houston, Texas. Let's go ahead and throw you up on the map. And while we're doing that, I want to give a big shout out and thank you to Kathy for gifting 5 Courtroom Confidential memberships. I appreciate that. I hope that whoever receives these memberships, I think you're going to love it. We put a lot of work into our membership program. I'll chat with you guys a little bit about that more. But thank you, Kathy. And thank you, Holly from Houston. Always good to hear from you. Yeah, we talked a little bit about this last week, but it's worth discussing a little bit more. AI, it used to be kind of this party trick. It used to be kind of just, oh, isn't this clever? You can ask it, show me a picture of a beaver surfing while eating a banana, and it would spit out this picture, and you go, isn't that great? You could prompt it to say, this is how much I use AI. I use Chat GPT to write bedtime stories for me. I say, give me a bedtime story for a 4-year-old about fairies and a magic forest, and they have to solve a mystery, and it pumps something out, and it's fantastic. June Sidolakis, thank you for the gift of memberships. I love it. We're getting things running this morning. Appreciate you encouraging everybody to be part of our membership program. But now AI does so much more than that. And it does so much more to the point that telling the difference, whereas before it was pretty obvious, now you struggle to tell the difference between an AI generated image, an AI generated video, generated voices, documents, what have you. It seems like it can do it all. It's incredible what they can do. A friend of mine, who's also a lawyer, took his criminal file, all of his police reports, and dumped it into some AI. I don't know what this system was. And it spit out a podcast. I'm not going to have a job in the near future, I think. It spit out an audio version of a podcast. It was an AI generated woman's voice speaking to an AI generated male voice about his case, as if they were telling the story of it like we're a true crime podcast. I am telling you all right now, had he not told me that was AI generated, I would have no idea. It was natural. They were talking and bantering and questions back and forth and laughing, and there was humor, and they were talking like 2 podcasters talking about this case as if they knew it really well. Blew my mind. Took a matter of minutes for it to generate that. So, to Holly's question, what are the implications of this in criminal courts when the authenticity of documents and pictures and videos and audio is incredibly important because somebody's life is on the line? Well, though there are not specific AI rules on the book that I know of now, I'm sure they're going to start drafting them. There is a rule already on the books that I think does cover this, and that is what's called the best evidence rule, or in the federal rules, it's Rule 1002 called requirements of the original. What this basically says is, well, it's one sentence, so I'll read it to you. An original writing, recording, or photograph is required in order to prove its contents unless these rules or a federal statute provides otherwise. I'm showing you guys the federal rules because they're oftentimes referred to as the model rules. I could show you California, but I feel like this kind of covers the US and you get a better understanding of, they're all kind of played off of the similar rules. Anyhow, what this says, the best evidence rule, is if you want to introduce a photograph, a video, audio, writing, what have you, in court, you're usually required to have the original. That's why chains of custody are so important. That's why you will call what's a person will sometimes be called to the stand who's referred to as a custodian of records. You will have a person come in to testify. I've seen this happen, to testify simply that the 911 recording you're about to hear is the original 911 court recording. And here's all of the chains of custody to show that to you. And that person is simply called to satisfy this rule. I think that you're going to start to see that happening more. When you see video, audio, photographs, what have you, you're probably going to have courts more concerned with the idea that that is in fact the original and not some AI generated or not some copy or not. I mean, and there's always been a problem, certainly with documents, of things being modified or not the original. The only times that you have exceptions to this is if they can prove that it was destroyed, the original, or it was lost or unattainable. But I think that the judges are probably going to get more strict about that kind of stuff. But great question, Holly. It really explores both a fascinating new tool and something that could certainly be used for much more sinister and nefarious purposes. All right. What should we do? We should keep it going.
Good morning, Courtroom Confidential. It's Simi from Thibodaux, Louisiana. This question is regarding Rodney Alcala. Apparently, he defended himself against Matt Murphy. I saw Matt Murphy say a little something about it, but I am really curious to know much, much more about that trial. And so maybe you could call your friend, Josh. Anyway, the Randy Alcala trial, that's what I'm curious about. Have fun with that, B-roll Queen Kaylin. Love you. Bye.
B-roll Queen Kaylin. Kaylin's not going to be beaten by this. She's going to find everything out about Rodney Alcala. Yes, you're right. Rodney Alcala, first of all, let's put Simi on the map here from Thibodaux, Louisiana. Great question. Rodney Alcala, oftentimes referred to as the dating game murderer. He was prosecuted and convicted by my friend Matt Murphy, and you asked what are his thoughts on it. Well, I could tell you his thoughts, or Simi, I could do you one better.
Hi, Simi. It's Matt Murphy. Joshua Ritter sent me your question. Rodney Alcala, yeah, he represented himself. A lot of the psychopaths tend to do that. And I think it's a combination of them wanting the control of subpoenas and also just kind of their own ego and narcissism, believing that they're smarter than their lawyers. So it was really interesting. What we did in that is we had to come up with a plan. And my trial partner, Gina Satriano, when he went pro per, we call it, and decided to represent himself, she didn't want to deal with him. So the plan we came up with was I would talk to him, I would be his buddy, and then every time we had to tell him no, I would just blame her. And it was fascinating because you wonder how serial killers can lure people into their cars, right? And we always think I would never get into the car. And then you deal with one of these guys and it's like, oh, that's how they do it, because they're really, really charming. If you want to see something interesting, watch the the Ted Bundy stuff, because he also represented himself, and they had a lot of similarities there. Those two guys, they were both prolific. They're really sadistic, horrific serial killers, active around the same time, and they both had that same desire to represent themselves. Unfortunately, they, as lawyers, so whatever separates them from humanity enough to make them want to rape and murder people, fortunately means they can't read the room in a trial. So I hope that answers your question at least a little bit. You can also, if you're interested, I wrote a whole chapter about it in my book, The Book of Murder. Did a whole chapter on Rodney Alcala, and that's it. Hope you're gearing up for an awesome 4th of July in Louisiana. And again, thank you for watching my buddy Josh. Yeah, have a good 4th. Bye.
There he is, the man himself, the legend, Silver Fox Day on Courtroom Confidential. Matt Murphy, he's such a great guy. Has an unparalleled resume as far as a prosecutor and defense attorney. Very brilliant guy, and he's just the nicest guy in the world. And I called him up. There he is in action. I called him up. He's on his way back from vacation and on his trip to somewhere else. And I said, well, put everything aside because I got a question for you and you need to answer it. And he said, no problem, dude. So big thanks to Matt Murphy. If you have not read his book, The Book of Murder, we'll include the link either in the chat or the notes on this so you guys can find it. But it is, I'm not saying this because he's my friend. I'm not saying this because I get any piece of it, which I don't. I will tell you, if you are a fan of true crime nonfiction, this is a fantastic book. He is a remarkable writer. I did not know that about him. I knew he was a fantastic lawyer, great in front of a jury. There's the link, but the guy can write. It is a really, really good book. And what he does is just kind of goes back through a lot of these high profile cases he worked on as a prosecutor, some that you've maybe never heard of. There was one case in there that I had not heard of that was one of the more fascinating cases I'd ever heard about. And he talks about the crimes in the prosecution, including the Rodney Alcala case. And it's got a long and tortured history, how it ended up being that Matt was the prosecutor. But he talks about this weird relationship that he had with Rodney Alcala. Rodney Alcala was a very charming guy. And it was kind of Matt's job to sort of disarm him and just not befriend him, but be kind to him till they could get through this trial. And then the way that Matt tells the book story, I'm not spoiling anything. But then when Matt gave closing arguments, he just lit into the guy as being one of the most evil, savage serial killers you're ever going to hear about. And he said that it almost looked like Rodney was hurt by that. I thought we were friends, kind of a deal. So anyhow, give a shout out to Matt. Tell him a big thank you. Go buy his book. I don't know, leave him a message on Instagram or something saying thank you so much from Courtroom Confidential for putting in the time to do that. And thank you, Simi, for asking the question and giving us an excuse to reach out to Matt. So good stuff. I do appreciate all the reactions from everybody in the chat when Matt came on. It looked like it was like a celebrity came out.
Hi, Josh and the team. This is Lynette from Exeter in England. This week I have a question regarding the difference between the US and English law. In as much as over here, you very rarely get to hear about a trial or information before a trial occurs. And so as a juror, you literally just get a letter in the post and you have to turn up for jury service. And unless you've got any relationship with anyone involved in the case, you sit. But you know nothing about it. Whereas in America, there's so much social media out there that you seem to know so much more before a big case that makes jury selection must be really hard to get an impartial juror. Also, the fact that over in America, you choose your jurors, whereas here you don't. And I just wondered what your thoughts were as to whether it is better to have a totally impartial jury as we do in England, who know nothing and just hear the case, or whether you find in America that by choosing your jurors, you've got more chance of not manipulating them, but more chance of directing them to the verdict that you want. Just interested on your thoughts. All right, have a great Sunday. Many thanks. Bye.
Lynette, thank you so much. Good to hear from you again from Exeter, England. So let's put the UK back on the map. There we are, Exeter. I'm so glad you asked this, because this is something I've been curious about and wanted to take the time to look into, but just never found the time. And now you kind of forced it on me. So I appreciate that. First, to the second part of your question, which is about jury selection in the UK and the US. I have to look into this more, is honestly the answer, as far as why the two countries decided to do jury selection differently. But your question is, isn't it better to have a completely impartial jury who knows nothing? 100%. Absolutely, you want that. But if you're telling me that I would have to take that at the expense of not picking the jury, that would be something I would not bargain for. I think picking the jury by the attorneys is an incredibly important part of the process. Why is that? Because people have biases beyond their knowledge of the case, or beyond even their thinking of the case. Sometimes it has to do with what they do for a living, life experiences that they've had, people that they're married to, where they live, all of this kind of stuff. And so your question was, do attorneys want to kind of manipulate the jury that they get? It's really not that. It's much more about eliminating people from the jury that you feel are not appropriate for that trial. When I end up with a jury at the end of jury selection, I think the idea of picking a jury is a misnomer. You don't really pick the jury. You pick who's not on the jury, is a better way to think about it. When I'm done with jury selection, every time I've ever done it, I usually, Your Honor, we accept this panel. Prosecution or defense, depending on where I was in my career, said, we accept this panel, put down our pens, and then I look over at 12 people that I feel like I know nothing about, because everybody else got kicked. Everybody who was prosecution friendly got kicked by the defense, and everybody who was defense friendly got kicked by the prosecution. And what you're left with is 12 people who kind of fall in the middle, didn't really have anything all that interesting to say, didn't offer a lot of strong opinions. If everybody asked me the question, how do I get off of jury duty, or how do I make sure I don't get picked? The way you make sure you get picked is just to say nothing. If you start talking and showing any kind of opinion, somebody's going to kick you. So it's not so much that like, oh, I really love juror number 3. I'm going to make sure that he ends up on my jury. Juror number 3 you love, and the other side knows you love, and they're kicking juror number 3. What you end up with is a bunch of jurors that neither one of you are all that thrilled about, but neither one of you are all that concerned about, and both of you probably know nothing about. But I think that's important, because there's a lot of things revealed through that whole voir dire and jury selection process that would be sacrificed if it were just 12 people who don't know nothing about the case. The first 12, great, you're on the jury. But to the other part of your question about the difference between the UK and the US on the media coverage of trials, this was fascinating to me, because we get a lot of people on this channel from all over the world, and a lot of them say we watch US trials because they're the only one showing the trial. They're the only one with the media really covering it. And I am fascinated by how other countries, to varying degrees, treat media coverage of trials. I know that in some countries, they won't even release the name of the defendant because they're concerned about people's privacy and everything else. Here, obviously, we do not. But as far as the UK is concerned, there was a law passed in 1981 called the Contempt of Court Act, and it created what's called a strict liability rule. What that says is that it is contempt of court to publish anything that creates, a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced, regardless of intent. That is a real chilling factor for the media. To publish anything that creates a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced. So you can understand why the media, other than saying, perhaps so-and-so has been charged with such and such and will be trial on such and such date, anything beyond that, you're looking at strict liability of being in contempt of court. The other thing they have in place is that all pretrial hearings, this is in the UK, there's an automatic ban on reporting the rulings of pretrial hearings. So by the time that something goes to trial, no one has any idea about all the pretrial hearings. Just to give an example of our recent Karen Reed case, we followed all the pretrial hearings. People debated it. The internet was set on fire with some of these rulings. In the UK, not so much. So those are some big differences between those two countries. Fascinating stuff. You want me to say which is better or worse? I think you could kind of debate that all day long, but just really interesting as to why I think a lot of people follow cases in the US. Tracy Fagan, thank you so much, says, Josh, can you do a conversation episode with Broken Baker about the differences? I would love to do that. I know that we've referenced him before. We've talked about it. I think he's actually been in our chat before or something, but I think that that's a great idea. And we will reach out to him to kind of get into that more because I think it's fascinating stuff. And it's not just the UK. I think Broken Baker's out of the Netherlands or something. I hope I'm not wrong. But I know that he's involved in that arena, and it can talk more about the differences between our countries on how we handle this, the what do you want to call it? The enforcement, the execution of criminal justice. Anyhow, Lynette, you're fantastic. Thank you so much. Let's keep it moving. Oh, I moved somebody's question. Was that somebody I already talked to? Sorry. Nope, not hearing it. Sorry. Hold on. I thought I did it right.
Hello, Joshua and Tiff and Kaylin and all the mods and everyone in chat. This is JC Broadway calling from Salt Lake City, Utah. I have a bar exam practice question. I'm going to ask the question. I'll leave another message with the options and then one more with the answers. So get your notepads out. Here we go. The question is, an elderly woman was mugged and robbed on a public street. At the time of the offense, the victim only saw her assailant's eyes. A hooded sweatshirt and bandana concealed the rest of his face. A few days later, while the victim waited to be interviewed, she observed the defendant being escorted through the courthouse in jail clothing and restrained by handcuffs and leg irons. She identified him as the perpetrator shortly thereafter. Will the court allow that identification into evidence? I'll leave another message.
Good one. JC Broadway. All right.
Here are your options. Number 1, no, because it is not reliable enough and there was too much suggestion to make a reasonably accurate identification. 2, no, because prior statements of identification are considered hearsay and never allowed into evidence. 3, yes, if the witness perceived the perpetrator by seeing his eyes and made the identification on that basis, it was reliable enough to be admitted. 4, yes, because the witness's recognition of someone is all that is needed. The reliability or credibility of it is subject to cross-examination. Write down your answers. I'll leave it in the next message.
Ooh, I like this one. All right, I'm going to give you guys a second to leave your answers in the comment. While you're doing that, why don't we thank JC Broadway and put Salt Lake City on the map? Thank you so much for calling in. I really like this one. So somebody IDs someone or sees someone more specifically, but all they can see is really their eyes because everything else is covered up. Later on, they see them in court and are able to identify them. And does that come in or doesn't it, and why? Excellent question. I'm seeing a lot of 4s. I'm seeing a couple of 3s. I'm seeing some 1s along the way. Tracy Fagan says 1. Wait, no, I changed it to 4. Krista J says 1. All right. All right. Drum roll, please. Let's get to our answer here.
And the answer is number 1. No, because it is not reliable enough and there was too much suggestion to make a reasonably accurate identification. And the explanation is the key question with eyewitness testimony is reliability. If it is shown to have sufficient indicia, I hope I'm pronouncing that right, sufficient indicia of reliability, it may be admitted without violating due process. Here, the circumstances demonstrated a prior identification that was so impermissibly suggestive as to give rise to a very substantial likelihood of irreparable misidentification. It also says, it is widely known that eyewitness misidentification is the leading cause of wrongful convictions across the country, which I knew eyewitness was not eyewitness testimony wasn't very reliable, but I thought most wrongful convictions were due to false confessions. Anyway, you all got an A+ for effort. Thanks much. Bye. Call me back.
JC, thank you for that question. This is a great opportunity to kind of explain all of this. And let me say first, I do agree with you, JC, that kind of editorialization from in the answer at the very end, I don't know if I entirely agree with. One, is it widely known that eyewitness identifications are a cause of bad prosecutions? I don't know if that's widely known, and I agree with you. I think false confessions are probably more a problem, but eyewitness IDs I would not call unreliable. I would just say that they are also suspect to question and are probably an area where jurors relying on them inappropriately is more of a problem. What I mean by that is that you hear somebody get up in court and say, that's the guy that did it. That's very powerful, but it should be explained the entire context of how that person's able to make that ID. Okay. But as far as that being the number one cause, I don't know. I'm going to have to do some research. Who wrote that question? Anyhow, great question. But it comes down to, like you said, reliability. So where I would say that the police could have cured this is had they presented that witness with some sort of photo array lineup ahead of time. But if you're saying that the person's first time in making ID was when the defendant was in county blues and shackled in court, yeah, that's bad. That's incredibly suggestive. And the other part of why that question, why the answer is number one, is because the prior identification when they saw the person was so poor. Had they seen the person's full face and got a clear view of them, then maybe we wouldn't be talking about that being inadmissible. But the fact that they didn't see them, only saw their eyes, and then sees the defendant and goes, oh yeah, that's got to be the guy. Incredibly suggestive and unreliable. And that's why the court uses that, or the answer uses that language of sufficient indicia of reliability was not present. So IDs all come down to the idea of reliability. Procedurally, you're talking about things like 6-packs, photo arrays, and what we also call a show up. A show up is when somebody commits a crime. The victim calls police. Police arrive, and as they have victim and are interviewing them, perhaps they have apprehended and arrested suspect. And what they do is they put victim in the back of the squad car, roll them out to where defendant is under arrest, show them a person handcuffed, and from the back of the squad car, they go, "Is that the guy?" And they go, "Yeah, that's the guy." Now, those are sometimes admissible, but talk about suggestibility, right? Calling me a guy that you're saying committed the crime, there he is in shackles. Well, it's not always that ridiculous, because many times they've said the guy who robbed me was wearing a plaid hoodie and had red sneakers on, and they arrest a guy with a plaid hoodie and red sneakers down the road who happens to have your cell phone on them that was robbed from you. And you go, "Yeah, that's the guy." That's going to be a reliable ID. And that's why they might not go through the whole idea of a 6-pack photo array. They use 6-packs in situations where crime has been committed. Later on, they want to try to get an ID out of someone. And so they go to them with this lineup and ask them to look through it. Now, you can have problems with the lineup. I mean, what if you've said that the person who robbed you had a tattoo on their neck, and the only person with a tattoo on their neck in that lineup is the guy in position number 4, and you ID position number 4, there's a problem there. So they will go through great efforts to create these lineups to not single out the defendant so that it causes trouble later on. And then a lot of it, reliability has to do with the circumstances of the initial perception of the suspect to begin with. You know, were they able to see them all that well? You're talking about a person with a mask and a hoodie, you know, a bandana on, and all you can see is their eyes. That's a problem. How accurate were they with their description? Were they able to talk about the bushy eyebrows and the full lips and the scar on the face and all that? And then also familiarity. I mean, if it's like I was robbed by the guy that comes into my store every morning for coffee, that's going to be a more reliable identification. But great question, JC Broadway. Thank you for the quiz. Appreciate you. And hello to Salt Lake City. All right, let's keep it going.
Hello, it's Madeline from Denver, as always. Kind of a random question that occurred to me as I was watching the last week's weekly roundup. Is it a thing to say, as a defense attorney, my client could not have done this crime because they had this injury? Or in the reverse, is it something that a prosecutor will say, they had this injury because they did this crime? Just got stuck in my brain, so had to ask. I hope everyone has a great Sunday.
Madeline from Denver, Colorado. I'm glad it got stuck in your brain. It's a great question. And it gives me an opportunity to tell you guys a little story. So Madeline asks about injuries. I'm curious, Madeline, how this did get inside your brain. What made you start to think about it? But she says that, can defense attorneys go, my client could not have committed this crime because of this injury that they have? Absolutely. Injuries, disabilities, you know, whatever, height problems, weight problems, whatever it is, whatever they could physical attribute they could point to in their client, say this makes it impossible for them to have committed this crime. Same thing with for the prosecution. You could say, well, listen, these injuries are a result of having committed this crime. And you make me think of a case that I worked on early on in my career at the DA's office when I was still a law clerk. I worked for a prosecutor by the name of David Walgren. You may know David. I should have told Kaylin to do some sleuthing on him ahead of time, but David Walgren was actually the prosecutor who prosecuted Dr. Conrad Murray for the death of Michael Jackson. That was kind of where he became very famous. But I was his law clerk, and we did a death penalty case with these two gentlemen here. This is on the right is a man by the name of Theodore Shove, and on the left is a man by the name of Lewis Hardin. And they were convicted for the brutal murders of an elderly couple named the Southers. I will get into the details of this story probably during like a members only live, but just to give you the rough outline, Shove there wanted to take over the Southers business, and the best way he thought he could do that was to intimidate them. And when that didn't work, he decided to brutally murder them. And he hired Lewis Hardin, who's on the left there, to break into their home in the middle of the night and bludgeon this elderly couple to death with a tire iron. And it was one of the bloodiest, most gruesome murder scenes you've ever seen in your life, because I'll give you a little bit of a graphic understanding. People do not die like they do in the movies. You hit somebody in the head with a tire iron, and that does not necessarily render them dead and unconscious immediately. People fight back, and it oftentimes takes several blows. And this was a bloody, bloody, gruesome scene. And how do we know it was a tire iron? Well, laying outlined perfectly in blood on the mattress, on the mattress cover of their bed, was a bloody outline of what clearly looked like a tire iron. Anyhow, one of the ways we were able to link Lewis Hardin to this crime is that his girlfriend talked about mysteriously seeing this cut injury on the palm of his hand. And we believed and argued that was from him striking them so many times with this tire iron that the other end, the handle end of it, had actually cut into the palm of his hand. So a really horrific case. One more little interesting tidbit about this. And again, this reminds me Tiffany, remind me for our next members only, I will give all the details of this case. But the jury in this case, it was a death penalty case, were so smart and so thoughtful that they decided to sentence Theodore Shove to death because he was the mastermind, though there was no evidence he ever even entered the house. And they gave Lewis Hardin life without parole because they realized he was just kind of the hired patsy. Really incredible case. Anyhow, to your question, Madeline, yeah, injuries matter a lot. Thank you for calling from Denver, Colorado. Oh, and thank you, Shy Gal, for the gift of a membership. Appreciate you. All right, let's keep it rolling here.
Josh, this is Judy from West Virginia, and I have a question for you. I was watching your show this evening, which is Wednesday, and you said that a prison guard could testify and talk about what the prisoner had said in jail. My question is, why isn't that not hearsay? I don't understand hearsay, I guess. Okay. Thank you from West Virginia. Talk to you later. Bye.
Judy from West Virginia. Let's put you on the map. Great question, Judy. You say, maybe I don't understand hearsay. You actually do understand hearsay. And I'll explain to you, however, why this is not hearsay, or rather is an exception to hearsay. So we were talking about the Bryan Kohberger case earlier, and one of the witnesses who is tomorrow going to be in court in Pennsylvania to argue why or why not he should have to travel out to Idaho for the trial is one of the jail guards from the facility where Bryan Kohberger was held after his arrest in Pennsylvania and before being extradited to Idaho. And I had made the comment that isn't that interesting, because a lot of these witnesses, we've been talking about them being possible mitigation or aggravating witnesses for the penalty phase, and just talking about Bryan Kohberger's character and as a person. And it might make sense that a jail guard to talk about, how did he conduct himself in jail might be a person. But then I thought, hey, as a jail guard, he may have overheard conversations. Bryan Kohberger knew what he was arrested for at the time. He may have been making comments. He may have been saying things, and that might be interesting evidence, not for just penalty phase, but for the trial phase too. This was just speculation on my part. But Judy picked up on that and said, well, wait a minute. How can a jail guard testify to what a suspect says? Isn't that hearsay? And you're absolutely right. Hearsay is an out-of-court statement offered for the truth of the matter asserted. So he's making an out-of-court statement, and the government would likely be trying to use it for the truth of what he's saying. The reason why that is not a problem is because the largest and most effective exception to the hearsay rule for the prosecution is what is called the party opponent admission exception. And again, here is the federal rules of evidence. This is rule 801 sub D sub 2, an opponent party statement. The statement is offered against an opposing party and then it gives kind of some other rules behind this. But basically, how this all breaks down is anything the defendant says, the prosecution can use. Karen Reed, all of her statements that they wanted to use could get in. Defense can't present her statements. Defense can't get up and present a statement that Karen Reed made ahead of time. That's not a party opponent to the defense. The defense doesn't have this advantage. And just so if you guys are kind of putting together the math on all of this, there isn't a party opponent to the defense. It's the people. There is no party on the other side. In civil cases, this becomes, much more kind of equal standing. But in criminal cases, it's the people of the state of the Commonwealth of Massachusetts against Karen Reed. So the Commonwealth of Massachusetts can get in any statement. The state of Idaho can get in any statement of Bryan Kohberger, and Bryan Kohberger's defense team can't get in any statement they want on him. If you want a statement from your client, you put them on the stand. So that is what this exception to the hearsay rule is all about. And that is commonly used by the prosecution. I loved using it. I would try to get every statement a defendant made in jail calls, conversations with jail personnel, telephone calls, recorded conversations, surreptitious conversations, interviews with people, any statements to the media, anything and everything the defendant said is fair game for the prosecution. So full-throated motion, I want to shake your hand. And that's why every day is STFU Friday, folks. That is absolutely right. That's why you keep it zipped if anybody from law enforcement wants to talk to you. And I don't care if it's, hey, can we just have a casual chat? They are going to use that against you. And you don't get to clarify it by something you may have said later on, unless you want to go ahead and take the stand. So great question. Judy from West Virginia.
Hey, Josh and everyone at Courtroom Confidential. This is Amanda, super planner girl, calling from Augusta, Georgia. And I was just wondering, I have a question about Karen Reed. And I know everyone is probably like done with Karen Reed because it's actually over now. But I saw when the juror was giving her interview, Juror 11, or I think it came out, through her interviews or people, kind of looking at her profile or social media and stuff, that she had indicated that she was a, quote, true crime lover. And I think people were saying that this maybe made her a biased juror, or, that she was somehow less qualified because of that. And I wanted to know, so this is tangentially Karen Reed related. I just want to know your thoughts on if a juror is a true crime lover, such as those of us who are here, who watch these YouTube channels, watch trials. Do you think that we should be excluded from being on juries, or do you think that we would make better jurors? And I would just like to know your thoughts on that. And I hope you guys are well. Thank you.
Amanda from Augusta, Georgia. Love this question. Nothing to apologize for. I realize the fascination of the Karen Reed case, and it just seems to keep on having a life of its own. Gisela, hello, my friend. Grizzly True Crime in the house. Hey, Kathy. I think people are asking amazing questions. I missed it. I think people are asking him, where's it go? I think people are asking amazing questions. I wanted to submit one, but got stage fright. Oh, please. Oh, please. The lady with the huge popular and beautiful YouTube channel doesn't want to leave us a message. I'm gonna make sure we get one out of you one day, Gisela. Thank you so much for being here though and saying hi. And I can already see the bear faces showing up in the chat. So thank you, appreciate you. Always love hearing from you, and we're gonna be chatting soon. I think I already kind of sneak previewed that for everybody. We would be so juiced if you left a message. I would love that. Amanda's question is great, and she talks about this juror number 11, and it is funny to me. I cannot think of the last time that jurors really went on a press campaign like we've seen from some of the jurors in this case. I know a couple of other jurors have made comments. I saw an interview with one on TMZ. Another guy, the foreperson, I think was on Good Morning America or something. But this juror in particular keeps on coming up in my Twitter feed even. And they do all seem to be having a moment. I will tell you, if I am Alan Jackson and his team, I am wishing these people just go on to their lives, because God forbid they say something ridiculous and it causes trouble, and somehow the Commonwealth tries to claw back something and make some sort of objection and say that somehow there was some sort of fraud upon the court, blah, 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 blah. I don't think it's going anywhere near that, and it would be absolutely mind-boggling if it did. But you kind of just wish these people would just be like, thank you for your service. Have a great life. Let's all move on. But this juror, I think, did make some comment, and I wasn't able to find it, but I think she made some comment about being a true crime fan. And Amanda's question is, should that have been disqualifying from being on a jury? And no, I don't know, not at all. But I think if I were prosecution or defense, I would certainly want to know that information, and I might have follow-up questions, and I might get a little nervous, a little sweaty palms for having somebody on the jury like that, because are they going to be a little too interested in all of this? I mean, one of the things you try to avoid as in jury selection is kind of people who are too eager to be on the jury. Those can be problem makers as well. You kind of want people disinterested in this world and just trying to do a good job. Tracy Fagan says, I love the foreman when the reporter asked who did it, and he said, that's not my job. I remember I did see that comment as well, and it's true. Not his job. His job, it was one simple question, guilty or not. But yeah, I think that what would be interesting to me is if she ever talked about her interest in true crime on any kind of jury questionnaire, or if that came out in voir dire. And if she was asked about it, was she honest about it? This is where problems start to arise. The issue, though, for the Commonwealth is that double jeopardy has attached. There's all sorts of other constitutional issues. But I'm curious if someone, and I'm not saying that's taking place here, but let's say someone had lied to the court to get onto this jury. Would that affect the verdict? I don't know the answer to that. It's something I'd have to look into. My question, though, for you, Amanda, is will anyone allow a retired prosecutor and a current defense attorney to ever serve on a jury? I don't think I'm ever getting the chance. As much as I'd love to, I think if I walked into jury selection and told them what I do for a living and what I used to do, both sides' heads would explode, and they would get me out of that courtroom as quick as they possibly could. And I'd probably be happy for it, because it takes up a lot of time to just serve on a jury. All right. Let's keep it moving here. This is a good one. A lot of good questions this week, right, guys? Are you enjoying this? I'm really, really thrilled by the array of different questions that we've got this week.
Hello, Josh. Hello, Courtroom Confidential. This is Court Lurker. I hope you are all having a wonderful Sunday. So my question has to do with discovery. Does a defendant / client get shown everything that's in discovery before the trial? And if that defendant / client is in jail awaiting trial, does that limit what they get to see or the process? I was wondering if you can explain that a little bit. Thank you. Have a great day.
Court lurker, thank you. But wait a minute. Where are you from?
Hi, Josh. Hi, Courtroom Confidential. This is Court Lurker again. I realized I did not say where I was calling from. I am in Spokane, Washington. I hope you guys have a good day, and thank you. Bye.
Thank you, Court lurker from Spokane, Washington. Let's put Spokane on the map. Appreciate you asking this question. This is why, in my view, one of the most important points in a trial for the defense that is often times kind of overlooked or considered as an afterthought is the bail hearing. Because the difference between defending somebody who's in custody and defending somebody who's out of custody is night and day. And it comes down to a lot of what your question is right here. First of all, to your question, does the defense get everything? Is the defendant themselves shown all discovery before trial? 100%. They have to. The discovery is not for the defense attorneys. It's for the defendant. The defense attorneys are just the ones who handle it and deal with it and organize it and figure out arguments about it. But the discovery is for the defendant. So everything is turned over to the defense ahead of time. Now, what do you do when the defendant's in custody? How do you show them all that stuff? Well, they are supposed to be accommodated in some kind of way. They are supposed to be given an opportunity to view all of the evidence. Now, they are not entitled to copies of all of it, which creates problems. The documents that are turned over have to have all the staples removed, which creates problems. They're not entitled to have access to thumb drives and CDs and everything else, which creates problems. So then they got to get access to a computer so maybe they can view a video, audio, all of that kind of stuff. Physical evidence. How do you allow a defendant to see the physical evidence? You can see, as you begin to talk about this, all of the problems that line up for somebody who's in custody. That's just the discovery issues and the review of evidence. How do you deal with a client who you can't see or talk to every single day? That getting to opportunity to see and talk to them is incredibly difficult and is not always entirely private. That is why the bail hearing is so important, because getting a defendant out to be able to defend them, it can be the difference maker in a case. And that's why, Sean Diddy Combs was willing to basically forfeit his entire fortune just for the opportunity to be out during trial. Sean Combs, by the way, may have a verdict tomorrow, as early as tomorrow. I think certainly by the first half of next week, we should be hearing something. Great question, Court Lurker from Spokane, Washington. Appreciate you highlighting that the other difficulty of being a defense attorney, which I deal with all the time until this YouTube project can take off and I can retire from that as well. All right, let's keep it moving here.
Josh, good morning. It is P. Lola's mom here at the Jersey Shore in the lovely state of New Jersey. So I have questions regarding Karmelo Anthony, who has unalived Austin Metcalf. These are students that were in Frisco, Texas, that were at a track meet. There is video of the stabbing of Karmelo Anthony stabbing Austin Metcalf. Karmelo Anthony yesterday was indicted on murder. That would be Wednesday. This occurred April of 2025. I'm hoping that you will cover this case and we can get some information regarding how you claim self-defense when there is a video, etc., etc. My question really is that his bail was $1 million. It's a lot. It's a lot of money for a young man and his family, but it was reduced to $250,000, which made it attainable for his family. So he's out on bail. So my question really is regarding not only the Karmelo Anthony case, but about bail in general. Murder is murder. And $1 million, I understand. These are also 17-year-old, I'll call them young men. I'm not going to call them children, because at 17, you know right from wrong. And when you pull a knife on someone, you know there's never anything good going to come out of that. So my question is about the bail. How does it go from $1 million to $250,000? What do you need to show the judge to be able to reduce it in such a great amount? If you can explain that to us, that would be wonderful. I'm hoping that everyone is having a wonderful Sunday. While listening to this, I will be at work. Hopefully, I'll be able to hear it at the same. And to my squirrel chat friends, I love you guys.
P. Lola's mom, I hope you are listening. Great question. Hello to you and hello to the Jersey Shore in New Jersey. So P. Lola's mom asked a question about this really awful case out of Texas. She did a great job of explaining it, but yes, this young man, Austin Metcalf, was murdered. I think that's clear. This is a murder. The story goes that he was at a track meet, a high school track meet. He got into some sort of altercation with another young man by the name of Karmelo Anthony. And it was something to do with, you see that pop-up tent that they have there? I don't know if it was that tent exactly, but a tent similar to it. If you've ever been to these track meets, a lot of the schools will put those pop-up tents up. And Karmelo was under the tent of Austin Metcalf's high school. And he told him, you got to leave. Undetermined at this point, we've heard varying reports as to how heated this conversation got. But Karmelo was saying he didn't want to leave. However, it came out. The way it ended up, though, was that Karmelo pulls a knife and stabs Austin Metcalf. Austin Metcalf, I believe after one stabbing, dies in his own brother's arms. Just a horrific case. And kind of to do with the question that we just had about bail, at the bail hearing, his defense team made a very impassioned plea to reduce his bail. And it was obviously convincing enough. And it was, however, caused a lot of controversy because Judge Angela Tucker did reduce his bail. $1 million for a murder, kind of standard. However, his bail was cut to a quarter of that. And the arguments made were that, one, his family could not afford the bail as it was set. Two, he had a lack of criminal history. And there were conditions placed upon his bail. It was $250,000, but he has to be on an ankle monitor and he has to be under house arrest. So P. Lola's mom's question is, how do we get there? How do we go from $1 million to now the young man is out and living at home? Bail, the purpose of bail is twofold. Many jurisdictions have what's called a bail schedule, where it's kind of like these are the accepted sort of standards for each crime. Murder might be $1 million. You have a weapons allegation, maybe that adds on another $100,000, whatever it is. It's all kind of this weird matrix and calculus to come up with a figure. Because the money isn't about taking money from people. The money is about creating an incentive. The money is about, we hope that realizing you could potentially lose this amount of money, that you will follow the rules that we're about to give to you. Okay. And that's because we don't have a better way of kind of ensuring that, but through money. It's something to compel two things. One, the court is concerned with the threat to the public. Is this person violent? And do I need to worry about violence being perpetrated on the public? And two, is this person a flight risk? Do they have a reason to not come back to court? And so bail tries to ensure that they will do both of those things. Keep in mind, you can post bail for the full amount. In other words, you can post, many times people go through a bail agent, but you can give the court, if it's $1 million bail, you can say, here's my $1 million. And at the end of the case, you get that $1 million back, because all that is insurance that you'll show up and behave yourself in the meantime. So there is this kind of strong, however, push in recent years with the thinking that because it's about money, it rewards the rich and punishes the poor. In other words, if a person is indigent and doesn't have two nickels to rub together, having $1 million bail is as much as having a $10,000 bail. They're still not going to be able to come up with it. And bail shouldn't just be about ensuring somebody's locked up. If you want to do that, you set no bail, which they can do in certain situations. First-degree murder can have no bail. But if you're going to set bail, it should at least be an amount that the defendant can reach, because otherwise it's pointless. So the arguments that a lot of courts are starting to entertain far more often is considering the financial circumstances of the defendant. And if they simply cannot pay $1 million, but they can pay $250,000, does that still give them a compelling reason to not commit further violence and to show up to court when asked? And if the court feels that, then yes, the court can reduce it. I will tell you, though, all of that being said, and all of those arguments being legitimate arguments, a reduction from $1 million to $250,000 is fairly extreme. I mean, I've seen reductions from $1 million to $750,000 or $1 million to even $500,000, but usually courts will say, listen, this is a first-degree murder. Somebody lost their life. They got stabbed. I'm sorry, but $1 million is $1 million. And if you can come up with it, great. If you can't, you're staying in jail. Because again, it's not about putting you in prison. It's about where do you go before your trial. Anyhow, really, really sad case, becoming a far more controversial case for a lot of other reasons. But I appreciate you, Pilola's mom, for asking the question. And thank you, Jody Arrington, for the gift of memberships. We got a lot of new memberships today. Kaylin, Tiffany, you got your work cut out for you. Those members are going to expect some good stuff along the way. So we will put in the work, and I appreciate you guys. All right. Let's keep it rolling here. Where's our next one?
Hi, Josh. It's Pam from Michigan. I wanted to at first tell you that I love how you introduced your new space. That was cute. I loved it. Great job, and it looks amazing. So, wanted to say that first. My question is, I'm not quite understanding the Bryan Kohberger. The judge in Pennsylvania, I guess, is meeting with people who are being subpoenaed that they don't want to go over to Idaho. I'm not really quite understanding it. I think I've heard different people talking about it, and I've heard it explained different ways, but I was wondering if you could talk about that. I didn't think that people who were being subpoenaed had a choice whether they can show up or not once they've been subpoenaed. So was just wondering, but anyway, have a great day. Thanks again for everything you guys do. Bye.
Pam, good to hear from you. Pam from Michigan. Pam's my mother's name, by the way. So hello, Pam from Michigan. Thank you for the shout out on our transition video for the background. Hope you're enjoying the new background. Tiffany wants to know what you think about this this plaid throw on the chair, by the way. She wants to know if you're fan favorites of that or not. Rowena Rains, thank you so much for the super sticker. But to get to Pam's question about the Bryan Kohberger case. Yeah, this is a little confusing. You're right. I thought if somebody was subpoenaed, they just have to show up to court. How does that work? I think the best way to think about it, Pam, and we talk about this, you know, in other circumstances, is that you got to think about each state as almost being its own country. Each state's got its own laws and own rules and own jurisdiction. And sometimes those states don't want to play nice with other states. And sometimes you want to make the citizens of my state do something. Well, you're going to have to go through some hoops and jump through some hoops. So the way it works, first of all, it's a real pain in the butt. I've had to do this before. To get an out of court or out of state subpoena is not straightforward, and it's different for every single state. Here's generally how it works, though. The state in which the requesting parties are at. So Idaho says, we want Pennsylvania citizens to come to Idaho for a trial. So first, Idaho asked that court to make an order. Idaho has made an order called a summons. They have sent that to Pennsylvania. Then you've got to get somebody in law enforcement in Pennsylvania to go out and serve these summonses on the Pennsylvania residents. So law enforcement's obviously cooperating with the law enforcement in Idaho, and they went out and served all of these people who are potential witnesses. By the way, doesn't always work that way. I've had out-of-state law enforcement, when I was prosecutor, tell me, yeah, we're not doing that. We're not going to, we don't got the time. We don't got the resources. We're not doing that. It's mind-blowing to me how sometimes some of the more difficult people to work with can be people that you feel are on your own side. Anyhow, Pennsylvania does. They go out and serve these people with a summons. All that is asking them to do at this point is to show up to court on Monday, tomorrow. Tomorrow is when they're going to have the hearing with these witnesses. And at that hearing is where a judge in Pennsylvania will hear, is there a compelling reason to make my citizens, who I have jurisdiction over, order them to show up to Idaho where they don't have jurisdiction over them? In other words, to submit my citizens to the jurisdiction and authority of Idaho. And on Monday, these people will come into court and say, give a reason why either they're not important, whatever offer of proof they have is not compelling enough to ask this person to travel all the way to Idaho. Perhaps that person's got other reasons. You know, they've got childcare, they've got, illness, whatever it is. They make their pitch to the judge. The parties, either the defense or the prosecution, will make their argument to the judge as to why they are super, super important. We need them to come to Idaho. And the judge in Pennsylvania will then order them to either submit to the subpoenas of Idaho or not. So we will find all of that out on Monday. And if you would like a further breakdown on how that all turned out, well, then tune in tomorrow night for our Monday Night Live with Kevin Fixler and get your Fixler Fix. And hopefully we will have a result of how that whole hearing went down tomorrow. So thank you, Pam. Great question. Tune in tomorrow night to get a better answer on how things actually end up on all of that. But that's all of the background noise that's taking place on the Kohberger case to get these potential witnesses out to Idaho. And by the way, I don't even know, this could continue on for a while because they aren't really needed until the end of the trial if they are in fact character witnesses for the penalty phase. So we shall see. All right.
Hey Josh, this is Casey. I'm from Abilene, Texas. I am Casey Lou in the comments section. I'm wondering about Kendrick Lamar. He's 17 years old from Georgia. On January 11th, 2013, he was discovered rolled up inside the gym mat at his high school. It was initially ruled accidental. The second autopsy was ruled blunt force trauma. Can you tell me your thoughts on this case and if you think the parents will ever get justice? Thank you so much.
Casey, Abilene, Texas. Let's put Abilene on the map. Great question. Sad case. A case I really was not all that familiar. Well, I wasn't familiar with at all, but we did some research on it. and Casey wants to know my thoughts. Just to give you guys, first of all, where's Abilene? I see Texas there, but where is it? Zoom in for us, Kaylin. She's saying, don't tell me what to do. I'm busy with other stuff. All right, there's Abilene. Here's what happened. In January of 2013, this is out of Valdosta, Georgia. I'm sure I'm butchering that name. 17-year-old young man, Kendrick Johnson. There he is. Such a tragedy. He is found inside of a rolled up gym mat, vertically rolled up gym mat, with his head first face down. The coroner does an investigation and they declare this to be an accidental death. And what they believe he died from was positional asphyxia. You may have remember that term from the Sarah Boone case, meaning somebody was just confined in a space for a period of time long enough that they eventually suffocated to death. So really, really tragic and sad story. Well, as sometimes you will see in these cases, the family, and I do not blame these people at all. You know, may God be with them. They are suffering a loss that they will never recover from. And I would not wish on my worst enemy to lose your child in this kind of a way. Well, they have a real difficult time accepting this as being an accident. And so they hire their own private pathologist. And this pathologist says that the results are that he believes that he died from blunt force trauma, or that blunt force trauma was somehow involved in all of this. Now, let me say this. Blunt force trauma, I am no pathologist, I am no coroner, but I've been doing this a very long time. I know that blunt force trauma can sometimes be a catch-all thing. Blunt force trauma means you got hit by something that we can't tell you what it was. We believe we see signs of either, it can vary. Blunt force trauma can be a crushed in skull, and blunt force trauma can be a bruise that you can barely see, okay? It just means something that we cannot describe, that wasn't an edged object, struck you and caused some sort of trauma, whether that be broken bones, lacerations, or just simple bruising. This causes the parents to really feel that there was foul play, and they end up suing the school, the county, the school district, 38 different individuals for $100 million, claiming murder and conspiracy. All along the way, by the way, law enforcement has never considered this a murder case. That case is eventually dismissed by a judge, realizing that there is no kind of merits to the accusations being made. Here's what my research revealed likely took place here. Apparently, and it's funny, when I was in high school, these are wrestling mats. They're large, kind of foam padded mats that you wrestle on. I was on the wrestling team in high school. There you go. Add that to your trivia list. These mats, though, take up a lot of space, and oftentimes they'll be put in like the basketball gym. Well, you can't have them sitting there the whole time, so you roll these things up. And you would roll them up, and then they would store them vertically. So in other words, not stacked on top of each other, like loaves of bread, but on their side and put in the corner. Just as an aside, to show you how psychotic things used to be for the wrestling teams years ago. I don't think they would do this to kids nowadays. One of the big parts of wrestling is that you have to cut weight. So we would all be concerned with losing weight before our wrestling tournament would come up. And one of the clever ways that our coaches would have us lose weight is he would actually have us wear our sweats and roll us up into these mats so that you're in this hot environment and you just sit in there and sweat. And it was awful and torture, but that's in a controlled environment where they could easily unroll you. Just one of the psychotic things you would do. You'd also run up and down the bleachers of the inside swimming pool area at the high school because it was warm and humid in there with your full sweatsuit on, running up and down, just doing everything you could to sweat. Real healthy stuff. Anyhow, they would have these rolled up mats, and apparently Kendrick, and this was something I didn't understand, would like throw his shoes on top of the mats whenever they were taking off their shoes to do whatever, and then would have to retrieve the shoes. And they believe, because a shoe was found, that he was alone trying to retrieve a shoe, had stuck his head down into the mat and probably fell down into it and then couldn't get back out. And that is a horrific way to meet your end, but it does sound like that's what took place. And now you're dealing with parents and family who simply cannot accept that as being true. And I will tell you that I've dealt with situations before in the past where someone meets their end under very troubling circumstances, whether that's they take their own life or some sort of accident. And it's really hard for family members to accept those things many times. And I think that's what's going on here. So to answer your question, Casey, I think it's just a horrific accident. And, you know, you say, will they ever see justice? I think they probably have seen it, and it's just not something they can accept. But case I was not really well aware of, and a really sad case out of Texas. But thank you for the question. All right, we're getting, I think, towards the end here. Let's keep it going. What am I doing wrong?
Hi, Josh. It's Diana. I'm from Salt Lake City. My question today is, why are people so interested in celebrity cases, such as Sean Combs, Blake Lively, Alec Baldwin, etc.? I don't get the obsession or fascination that people have with them. Do people just really want to see that stars are fallible too? To me, they're just soap opera stories. True crime is more interesting when everyday people are involved. Thank you. Love your show and take on cases.
Thank you, Diane. Salt Lake City. I think we heard from somebody else from Salt Lake City today, but let's put Salt Lake City back on the map. I like this question. You know, I think you're right, Diane. I think people do care about celebrity cases because there is a part of us that has this kind of Schadenfreude thing where we want to see the rich and wealthy and powerful and famous fall from grace as well. I think some of it is not entirely so cynical, but it could just be, wow, I know this person. I mean, I remember when OJ got charged with murder, my first reaction was not OJ. He's that goofy guy from Naked Gun. You know what I mean? It was like, but we all became fascinated with it because it was OJ, but it was also a incredibly important and serious case. But I agree with you to the extent that a lot of times these celebrity cases will take up more space in the room than they should, and they're not all that interesting, whereas other cases involving less known people are far more fascinating, as far as if you're interested in trials and facts and how investigations are done and the drama. I've handled cases with the kind of drama that would absolutely outshadow a lot of the cases that we cover because they're popular, that had zero people in court watching them. Just fascinating drama being played out in court. Never hear about these things. So I do agree with you, Diane. I also think it is a great idea for one of our Tuesday polls. So Tiffany, if you're listening, if you're still there, if you're still in the house, if you haven't run off with my kids, I think this would be a great idea for a Tuesday poll. Like what are the kinds of cases that you're interested in? Is it celebrity cases or less known cases or cases involving, I don't know, families or cases that were cold cases? Great question, Diane. It really gets us thinking. All right, let's keep it moving. No? Ay, vey. I'm doing the same thing I do every single week. What am I doing wrong?
Hi, Josh. My name is Lindsay, and I'm from Cincinnati, Ohio. And I am newer to CC, but I'm just curious what got you into being a lawyer. Were there certain trials or things that you watched? What got you inspired to do what you do? I thank you, and I enjoy watching CC every week. Have a good day.
Thank you so much, Lindsay from Cincinnati, Ohio. What a kind words for you to say. I'm glad that you're new and I'm glad you're enjoying it. And I hope you stick with us. And great question too. What inspired me to become a lawyer? Well, I will say this. Initially, I did not want to become a lawyer. My father was a lawyer. My brother is a lawyer. I think there was a part of me that said, I don't want to do that. I want to kind of blaze my own trail and I don't want to become a lawyer. But I think there was also a part of me that saw that as almost like my destiny. I will tell you, I went to college not for law initially. My major's in English, ironically. But I thought, I don't know, I thought maybe I'd wanted to get involved in writing or the movie industry or whatever it is. But eventually you start to think about creating a career and a future for yourself. And the law just seemed like a great tool to have. Whether or not I practiced law or just had it as a tool, it seemed like it was going to be good for advancement in my life. And here's a perfect example. I mean, I don't think I would be doing this channel, and it certainly wouldn't have the experience to be talking about these things or education to be talking about these things had I not been a lawyer. So, maybe one day I won't be a fully practicing lawyer and still have a career, and having been a lawyer will benefit from all of that. But I think I went into law school kind of kicking and screaming, but I've enjoyed it ever since then. And yeah, that's how I ended up here. So thank you, Lindsay, for that question. I appreciate it. Okay.
I live in Burlington, Ontario, but I'm originally from Moose Jaw, Saskatchewan. So I'd like to put Moose Jaw on the map. Anyway, I can get into the history of Moose Jaw if I have time. But I want to go right back to the very basics. How in the world do you actually even hire a lawyer? Like, I've had real estate lawyers and divorce lawyer, but I wouldn't even know where to begin to find a criminal lawyer. Like, how did Karen Reed come up with Alan Jackson? It's like mind-boggling to me how you go about finding a lawyer. Anyway, Moose Jaw, Saskatchewan is known for its connection with Al Capone, and you can check out the tunnels of Moose Jaw and you can learn about Al Capone and the indentured Chinese slaves that were used to create the railroad in Canada. Anyway, thanks to your members who gave membership. I received one. Great. I maybe went over time. Anyway, just wanted to thank your great CC crew for donating a membership. I was one of the ones to receive it, and I enjoyed catching up on past episodes and just wanted to say thank you. And yeah, I'm enjoying the podcasts, and yeah, hugs from Canada. Bye.
Hugs from Canada. Hugs right back at you, Lori. Thank you so much. Lori from Moose Jaw, Saskatchewan, Canada. Let's talk about Moose Jaw first. I love that. I love that you gave us a little history on Moose Jaw. I wish I had done a little research into where the name Moose Jaw came from. Maybe next time, Lori, you'll call in and tell us a little history of the name. But we did look into the tunnels of Moose Jaw, which was fascinating. And it was apparently, there they are, this elaborate kind of underground railway sort of a situation for running alcohol to the U.S. during Prohibition. It looks like it was also a place for illegal gambling and prostitution. When you talk about tunnels, I'm thinking about something far less elaborate. I mean, this is like living quarters down there in Moose Jaw. So you guys have a history of being up to some tomfoolery in Moose Jaw. Moose Jaw is cool. The tunnels are amazing, says Debbie M. She's been there. Tiffany put it on our list as to the next trip we're going to take. And yeah, apparently Al Capone, it's kind of one of those things that Al Capone may have or been likely, but I think the research I saw was nobody could find a picture of him, but not surprising that he wouldn't exactly be taking photographs. Gizla's taking us all on a walk with her. Enjoy, get your exercise. Appreciate it, Gizla. I appreciate you still being here. Yeah, Moose Jaw. So how do you even hire a criminal lawyer? Well, I'll tell you the story of how Alan Jackson and Karen Reed found each other, and then I'll tell you another story about just being a criminal defense attorney. But story goes, Alan represented Kevin Spacey. Kevin Spacey, if you may remember, was charged with a sexual assault situation out of Martha's Vineyard, and he went out to Massachusetts, and it got a lot of attention out there, and it kind of put him on the map in the Massachusetts community. Wasn't, the law firm in Los Angeles, and I was still at the law firm at this time. The law firm in Los Angeles wasn't exactly getting a bunch of calls from Massachusetts, but Alan goes out there, defends Kevin Spacey, gets a good result for him, and then the Massachusetts community was kind of like, if I'm in trouble, I'm hiring this Alan Jackson guy. Fast forward a little bit later, Karen Reed gets charged. She hires David Giannetti. She feels like, I need to really beef up my team. And she reaches out to Alan, just a cold call email. I believe the email was something along the lines of, I'm being charged with a police officer's murder or something like that. Alan gets interested. She sends the photographs. He starts to feel like, hey, maybe there is something here. I was not in the firm during that time, but anyhow, gets involved in the case. I don't think he had any idea what it was going to turn into. He's represented some other people out in Massachusetts, and it's never made this much news, but had no idea that it was going to kind of take on a life of its own, and it absolutely did, and is now kind of a watershed case for him. But that's how she found him. She just knew about his reputation and reached out to him. And that is sometimes how you find a defense attorney. I will oftentimes meet people and they go, what do you do? And I go, oh, I'm a lawyer. Oh, what kind of a lawyer? I'm a criminal defense attorney. And they go, oh, it's always the same reaction. Oh, because they're expecting, oh, I deal with, mergers and acquisitions or something like that, that their eyes are going to kind of roll back in their head with boredom. But I go, criminal defense attorney. They go, oh. They go, well, I hope I never need you. And then they go, but do you have a card? And everybody seems to want to have a criminal defense attorney's card in their wallet. I have people that I've met years ago that to this day, when I see them again, they go, I still got your card in my wallet. Tiffany and I, one time before the kiddos, were enjoying a nice little staycation at a beautiful hotel here in Los Angeles called the Beverly Hills Hotel. Very famous, very beautiful hotel. And we were enjoying some time by the pool. And I start chatting up this young man next to me. And he's kind of like the life of the party. He's like, knows everybody at the pool, real mover and shaker young kid. And we get to chatting. And he says, what do you do for a living? And I say, well, I'm a criminal defense attorney. He goes, no. Can I get your card? And I start laughing. But I hand him my card because if you're a criminal defense attorney, you always keep a few of them on you. And I say, why do you need it? And he goes, well, I'm involved in the marijuana industry. And I said, okay, that makes sense to me. Anyhow, flash forward, I think a couple of years later, I think we were actually, Tiffany and I were at the hotel where we got married, kind of checking out the venue. And I get a phone call from an unknown number. I answer it and he goes, "Hey, you remember me from the Beverly Hills pool?" And I said, "I probably will never call you, but here I am." And I ended up representing him. So that is not an atypical situation where you just randomly meet someone. They know that maybe they might need your services one day and they keep a hold of your card. I would not suggest that, Lori, as far as how to find a lawyer. Oh, Kevin, see you all Monday. Good to see you, buddy. Yes, we will see you Monday. We're looking forward to it. I hope the hearing's still on for tomorrow. If you know, let us know. But looking forward to chatting with you. Anyhow, Lori, I would say do some research, talk to some friends, probably not just hang out a poolside trying to find a lawyer. Anyhow, thank you for the question. Hello to Moose Jaw. All right, we're getting down to the final few here, guys. Fun day, Sunday, fun day. I hope we lived up to the name, and I hope you guys have enjoyed it. Let's get down to our last couple of questions here. It's still on in PA as far as I know. Okay, well, you're the guy who should know. You're the guy the guy I expect to know. You're on top of all things Kohberger. We'll see you tomorrow, buddy. Good to see you, and we will see you tomorrow. Appreciate you, my friend.
Hi, Josh and CC crew. It's Joy W. from Ottawa, Ontario, Canada. Just wanted to ask you a question about third-party culpability, or the "some other dude did it" defense. I know they tried that in, I think it was the first Karen Reid trial. It was denied in the second Karen Reid trial, and it's also been denied in Kohberger. And I was just wondering, what is the standard that it has to rise to be able to bring that defense forward? Like, how much evidence does the defense have to have against someone else? And in that case, too, does it shift the burden then to the defense? Just wanted to hear your thoughts on that. Thanks, and really enjoying the show.
Joy from Ottawa, Ontario, Canada. Great question. I love how smart our community is. Did you ever think in casual conversation you'd be chatting about third-party culpability, but now you guys know what it is and you can chat about it. But this is coming up. You referenced Karen Reid. It was an issue in that case. It's become an issue in the Bryan Kohberger case. Recently, the judge decided that he's not going to allow for them to argue this. And so Joy wants to know, what exactly is the standard? Oh, there's Joy. I left a message before you answered it on the roundup. Sorry you had to repeat it. Motion to name the sad little plant. Oh, Norman. No reason and not after anyone. I love that. Norman. That's what we should do. We should have a poll or some sort of prize giveaway. Write this down, ladies, on naming the plant. That's our next project. How do we name our little plant? Can we see we can even see it in the shot that we have now, but our little plant from our old days. There he is. There's possibly Norman. I think somebody else said Planty. But that's who survived from the old floating shelf days. The plant is called Leaf. Anyhow, third-party culpability. Back to business here. What is the standard? Why is the Bryan Kohberger team not being allowed to use it? The standard obviously is different from state to state, but they generally all follow the same concept. In Idaho, it follows a case called State versus Meister. And really what that comes down to is a two-pronged inquiry. First of all, is the evidence relevant? Meaning more or less likely, more or less probable that the defendant is guilty. That's how something becomes relevant. You can't just bring up, hey, by the way, there was some people acting suspicious. There's drug activity in the area. all of these things may be true, but are they relevant? Do they move the needle? Do they prove that it is more or less likely that the defendant committed the crime? So that's the first thing. And that really has to do with the idea of creating an evidentiary nexus between the suspect that you want to proffer and the evidence itself. Two, and it sounds like a lot of these 4 people that they submitted failed on that front alone. But 2, then the court, as in most evidence, has to do a balancing between probative and prejudicial evidence. In other words, by prejudicial, it means, will this just be confusing to a jury? Will it just be misleading to a jury? Will they hear about this other suspect and go, I'm not quite sure how to handle that, but now that makes me confused as to what I'm supposed to do, or maybe I'm being misled by this other evidence. In other words, you don't get to just throw stuff against the wall. You don't get to create and manufacture red herrings for the jury. There has to be evidence specific enough, rising to a level of convincing enough to connect another person to the crime, to the exclusion of the defendant. That's the other thing about this. You can't just say, hey, we found unidentified male DNA. Isn't that interesting? How does that make your client, Bryan Kohberger, less guilty? Bryan Kohberger's DNA was also found there. The fact that other DNA was found there doesn't mean his DNA wasn't found there. So excellent question, Joy. The judge decided this issue, but I'm glad that you asked it, and I'm glad that you were here to get the answer. All right, guys. It's that time. It's that time. It's our very last question. We have other questions that you guys left past our deadline. We're going to get to all of those next week. We tried to answer as many as we could this week, but bringing us home on this beautiful Sunday. Let me just make sure I don't ruin the moment. Here we go.
Hi, Josh. My name is Lori, and I'm from Bolivar, Ohio. I've been following the trial of Raul Valle in Connecticut, and I am so distressed. I heard you mention the other day that these kids' brains aren't even fully developed yet, which is so true. And their thinking was clouded by alcohol and, I guess, raging testosterone. But this is one of the saddest cases I've ever seen. I mean, I was a teenager in the 70s in a rural area, and let me tell you what, just watched Dazed and Confused. My friends and I were just lucky or blessed that nothing like this happened to us. But the more I hear out of the witnesses, the more it sounds like the Valle kid just went after a kid that wasn't even in the fight. Anyway, here's my question. When did we start trying children as adults in the US? And what are your thoughts on it? Because it truly bothers me. Thank you.
Lori from Bolivar, Ohio. Thank you so much for leaving the question. A great question to lead us out on. You're asking about the Raul Valle case, but before we get into Raul Valle, let's talk a little bit. You referenced the movie Dazed and Confused, the cult classic from 1993. I love this movie. If you guys have never seen this movie, you got to check it out. I was asking Kaylin if she's ever seen it, and she said she's going to have to watch it now. Just a great film. I think it was Matthew McConaughey's, a very young Matthew McConaughey's, like, first major role, and he's fantastic in it. A lot of big actors that you may recognize also kind of as very young people in this movie. It was, like I said, released in 1993, and it was about a bunch of high school kids graduating in Austin, Texas in 1976. And it was a period piece for the time. I'm about to blow your minds. 1993, the 1976 period piece would have been 17 years old. We are now in 2025. 1993, when this film was released, was 32 years ago. That made me want to fall over. In other words, that would be like a movie today being a period piece about kids graduating from high school in 2008. When I put together this information, I wanted to just sit in my rocking chair with my Afghan blanket and just retire, because that blew my mind. Anyhow, thank you, Lori. Check out Dazed and Confused, but that isn't really your question. Your question is about Raul Valle and about trying young folks as adults. Joshua, those facts are harsh. Yeah, I should have given a trigger warning ahead of time. Watch out. Watch out. Hard math coming in hot. Anyhow, when did children start being tried as adults is more to Lori's question. And we're talking about James McGrath, pictured there, he was murdered, or he was stabbed rather, by Raul Valle. That trial is on right now. We've been covering it a little bit, but they're all young folks. I think Raul was 17 at the time, maybe younger, 16. I'm not sure. They're still children, and he's on trial for murder. And Lori's like, when did we start doing this? When did we start putting minors on trial as adults? Well, the answer, actually, the question should be, when did we stop? The history of trying children as adults has existed for essentially forever. I mean, you have to go back all through American history. That's just what it was. The first time that there was a actual juvenile court was from 1899. That was the first time that they decided to say, maybe we should treat juveniles different than adults. And the idea of rehabilitation being more the point with juveniles than punishment as it is with adults. Obviously, we've advanced quite a bit since then, but even in the the hard on crime 90s, the idea of trying juveniles as adults was much more aggressively approached. It is only until recent years that they've been showing a lot of kind of pushback and discretion, and with advancements in kind of how we view the development of the human brain and all of that stuff. But it's still fairly common, especially in very, very serious cases involving murder. The idea that a 16 or 17-year-old would be tried as an adult for a murder like this is not all that outrageous. But the way that it is done is that when a person is a juvenile, when they are a minor, that the presumption is they are in minor court. And then usually the process, sometimes they can direct file, but usually the process is that a hearing is heard on whether or not certain factors are met to try that person as an adult. And in California, it's called a fitness hearing. Can they be fitnessed up to adult court? And the court will consider things like the circumstances and seriousness of the offense. So here we're talking about a murder. It was a stabbing. The degree of sophistication in the crime. This was a crime that was committed in the course of a fight, not all that sophisticated. Maybe if you had a premeditated murder with a lot of deliberation and planning and lying in wait, that would be a factor, in favor of trying them as an adult. And then a lot of it comes down to like prior criminal history and the ability or potential for rehabilitation. Because like I said, in juvenile court, it's much more about, this is a young person. How do we get them back on track rather than punish them for what they've done? How do we turn them back into a contributing, successful part of society? And so what is their potential for that? Are they a lost cause, or are they somebody who rehabilitation might work for? So interesting stuff. LVX9 says this one is really hard to watch. They also refer to Raul as a man because he is now, and victim as a teen, but they were both teens when it happened, not justifying any of it, just really complex and sad. I totally agree with you. It is complex. It is sad. And it is, and it is true. One person lost their life as a child, and the other person is on trial as they sit here an adult, but were very much still a child at the time that the crime took place. Anyhow, what do you guys think? Did you enjoy yourselves? You got to talk about Dazed and Confused. You got to talk about Moose Jaw. We got to talk about what else? Karen Reed, Bryan Kohberger, Rodney Alcala. You got to hear from Matt Murphy. Next time you see him on Twitter or Instagram, send him a big shout out from Courtroom Confidential. So glad that he was able to join us and give us that little treat. Let me give you some quick announcements and get you guys out of here. One, if you missed it, yesterday we released our weekly roundup. It's now being released as a live premiere every morning at a new time, 8 a.m. Pacific, which is 11 a.m. Eastern. This week we talked about Bryan Kohberger and Barry Morphew and Sean Combs and Lori Valle, Lori Daybell, all of the big cases that are going on right now. Please check it out. If you haven't watched it already, check it out. It's 30 minutes long and you'll get to know all of the news that took place this week. Monday, as I've said before, if Kevin's still here, say hi to Kevin again, but he will be with us tomorrow night for our live Monday night special. Time's up for Bryan Kohberger. He's heading to trial. You're going to get your Fixler Fix. That will premiere tomorrow live on this channel at 5 p.m. Pacific, 8 p.m. Eastern. When we are done with that, do not go anywhere because I'm going to, through the magic of YouTube, transport you over to Linda from It's a Crime, her channel, because I'm going to be on her channel and she's going to be interviewing me. And we're going to be talking a little bit about the Barry Morphew case and some other things going on and just getting my thoughts on some of the trials that she's been following. So we're doing a back-to-back. First, our channel at 5 and then her channel at 6 p.m. She said she shows Mountain Time there, but 6 p.m. Pacific, 8 p.m. Eastern. Wait a minute. Do we have that right? No, I'm sorry. That is right. 6 p.m. Pacific, 9 p.m. Eastern. I'm tired, guys. It's been a long day. Don't ask me to do times now. So that's Monday. Then on Wednesday, we're doing our Wednesday night live, and our guest will be Gisela. Are you still on your walk, Gisela? Did you get your steps in? Gisela from Grizzly True Crime, and we're going to be chatting about all the stuff that she's following. Stephen Stearns, there's some updates, probably some more Bryan Kohberger stuff. So don't miss out on that. That will be this Wednesday at 5 p.m. Pacific, 8 p.m. Eastern. Before I let you go, where in the world, please tell me, Joshua, where in the world can I go so that I can leave a message next time? All you have to do is go to thecourtroomconfidential.com and click on, hold on, what am I doing here? Click on this button right over here to the right. Send a voice message. This box will pop up and then you just record. You get 1 minute, 30 seconds to ask us the best true crime question that you've got, or just to say hi. And if you want to then decide that, hey, this is some good stuff, how do I become a member? You click on this, become a member, hear about all the benefits of that. And then after you become a member, you go right over to our shop and buy yourself a brand new shirt, like the one I'm wearing today, which is Purple Dreams, Purple Haze. What's it called, Kaylin? What's it called? A race between Kaylin and Tiffany to tell us the name of this. Violet. No, that's not all that inventive. But you can buy this shirt and all of the other colored shirts that we've got here on our shop on thecourtroomconfidential.com. You guys have been fantastic. Thank you, everybody. Did I miss thanking anybody who left us, who became members? Here we go. Fauna the Forest became a YouTube member, and Arizona Gal, thank you so much for the super chat, and Jami Shari for becoming a member. Who else? I don't want to miss anybody for being here. Sherry M became a brand new member. Annalie Finch for the great for the super chat. Kathy for gifting the memberships. June for gifting the memberships. Tracy for the super chat. Thank you. Shy Gal for the gifting the memberships. Tracy again. Thank you. And Jody for gifting memberships. Wow, you guys are fantastic. Super sticker from Rowena. Joy W for a super chat. Thank you so much. You guys are all fabulous. I think that's everybody. I want to give a special thank you to, of course, Kaylin and, of course, Tiffany for running everything in the background, and to our mods for dedicating so much time and attention to making this chat as wonderful as it is, to Afton and Sonia and Kathy. You guys are all fantastic. Thank you all so much for being here on Sunday. Enjoy the rest of your Sunday. We will see you tomorrow night. Take care, everybody.